Consequently, for most of the first half of the 20th century, the lives of black Louisianans remained unchanged. With the loss of voting rights, they could not hold accountable their elected officials, including Supreme Court justices for whom they could not vote. Unable to demand equality, they begged not for an equal slice, but for crumbs. Even Walter Coyne, the South's highest-ranking black office holder, conceded his racist impotence. Said Coyne, "We recognize that this is a white man's country, and we are at your mercy. We are not desirous of social equality." Coyne was aware that only 598 of the state's more than 190,000 registered voters were African Americans. I'll repeat that. In 1923, only 598 of the state's more than 190,000 registered voters were African Americans. And such political impetus not only affected African Americans in selecting public officials, but also in seeking justice in the state courts. Generally, black litigants, if possible, sought judicial relief in federal courts. But sometimes state courts could not be avoided, especially in criminal matters. During the first half of the 20th century, the bulk of cases brought before the state Supreme Court involved criminal appeals of black defendants convicted of murder and sentenced to death. In most of these cases, the appellants alleged the exclusion of African Americans from juries in violation of both state and federal constitutions. In the majority of the state parishes, no black had served on a trial jury for more than a half-century. Since jury pools were drawn from voters' lists, it followed that the chance of selecting even one African American juror was infinitesimal. However, in 1935, the state high court did order the retrial of a black defendant in Washington Parish, not because there were no black jurors, but because his defense counsel had not been given sufficient time to prepare his case. The lawyer met the client a day and a half before the trial. The court's ruling notwithstanding, a mob entered the prison, lynched the defendant before he could be retried. And even though the perpetrators were known, no one attempted to bring them to justice. Only 4 of the 300 potential jurors for both the grain and trial juries were black. Instead, the court concluded it is reasonable that jury commissioners should prefer members of their own race. It is not their duty to search the parish for members of the colored race who possess the proper qualifications, merely in order that their names be on such persons on the roll. The justices failed to explain whose responsibility it was to assure a fair cross-section of potential jurors. Despite a successful appeal to the United States Supreme Court, this defendant was subsequently retried, convicted, and executed. Because civil rights laws usually bypass state courts in favor of the federal courts, the state Supreme Court played only a minimal role in the activist phase of the civil rights movement as it heated up in the 60s. But in 1962, it reversed the conviction of members of the Congress of Racial Equality who had been convicted for distributing leaflets on Canal Street. However, in a related case, it sustained the conviction of a Corps field secretary for using inflammatory speech, which turned the protests into a seething mob. Eventually, because federal civil rights laws and court decisions ended most forms of legal segregation throughout the nation, there was not much good at home for state courts to do. In an interview I had with former Chief Justice John Reneau, he indicated that after the passage of the Civil Rights Act of 1964, he ordered removal of all race-related signs from the court's restrooms and seating areas. In a strange twist of fate, though, Reneau later had to depend on support from attorney A.P. Turo to secure black votes when he ran into an unexpected challenge to his seat in 1963. Even after the passage of new civil rights laws, there were still criminal cases alleging jury exclusion, such as the conviction of NAACP State President Emmett J. Douglas, who was convicted of setting off a riot in 1969 in Baton Rouge. He was convicted by a vote of 11-1. The lone vote for acquittal was cast by the only black juror. But in a narrow 4-3 vote, the High Court overturned the conviction because it infringed free speech. Of note was the 4th and deciding vote cast by the court's newest member, Pascal Caligaro, who Douglas affectionately dubbed Saint Pascal. Over time, the court's views changed, especially as the political fate of African Americans changed. No longer voteless, by the mid-70s, this former impotent constituency had gained power and could no longer be ignored. The court's new moderation also resulted from the adoption of the new state constitution in 1974, with its enlightened Bill of Rights, which specifically repudiated separate but equal and declared voting a fundamental right. The state judiciary was also infused with an increased number of black judges, including membership on the highest court itself, which is now led by a black woman. The civil rights movement has been transformed. It is no longer limited to advocating on behalf of black Americans only, but also women, gays, lesbians, the aged, the handicapped, a larger and more powerful constituency. Undoubtedly, in the future, its members will find a more sympathetic hearing from a court whose diverse membership now reflects more accurately the entirety of this state. The state Supreme Court treated blacks the way most courts treated them for much of the 19th and the 20th century, because they were voteless, didn't have much political power. Changes did not come until the Civil Rights Revolution began to have an effect. And then slowly you began to see a change of attitude, as you also saw a change in personnel on the court in the 1970s. Thank you, Professor.
Our next speaker was recently appointed Louisiana Supreme Court Bicentennial Historian by the Justices of this court. Professor Warren Billings has published numerous books and essays on Louisiana law, the Louisiana Supreme Court, and the court system. He is a distinguished professor of history emeritus from UNO, where he was a member and later chair of the history department faculty from 1968 to 2005. Currently, he is visiting professor at William and Mary Law School. Professor Billings' most recent work is entitled Magistrates and Pioneers, Essays in the History of American Law. Today, Professor Billings will speak on the history of the Louisiana Supreme Court.
Thank you, Governor, and thank you all for inviting me. As I was listening to my colleagues talk, my mind ran back to two events in the history of this court. One was exactly 100 years ago when the court celebrated the bicentennial of its founding. And what I remember, what I was reminded of about that is the principal address was delivered by Henry Plauchet Dart, somebody whose name is probably known to some of you. Dart's address was about 75 pages long, which meant that he probably talked for 3 hours. I don't intend to talk for 3 hours. Y'all would shoot me. But the other thing, the other episode that I was thinking about was when the court met for the very first time. There were only two judges, Dominic Hall and George Matthews. They constituted quorum. There were only 3 judges of the Supreme Court at that point. There was very little ceremony that we know of. You know, they convened in Government House. I doubt very seriously that they were piped in by a military guard. There was no pledge. In fact, the meeting didn't last very long at all. All it amounted to was the commissioning, the reading out of the commissions, qualifying Hall and Matthews to be members of the court. And because Hall's was read first, he became the senior judge. And that established the precedent of the senior judge being the presiding officer. It wasn't called Chief Justice until 1845. Now, these guys didn't have a very good idea of what they were about. The Supreme Court had been created by constitutional amendment, as Professor Trahan mentioned, as a condition of statehood. And state Supreme Courts in the early part of the 19th century were not very clear about what they were supposed to do. The whole invention of a Supreme Court was something that came out of our Revolution. And it is one of the reasons, one of the things, because the courts didn't have very much to do, is one of the reasons why courts all across the nation, Supreme Courts all across the nation, got control of qualifying who became members of the bar. And until in the 20th century, it was the justices of the Supreme Courts of the several states who actually quizzed prospective candidates. And that became a pressing issue in this court, practically overwhelmed the court in the 1840s, and it led to the court's involvement in some reforms to legal education and also control over the bar. The other thing I was thinking about as I listened to my colleagues talk is we know more about the Supreme Court of Louisiana today than at any time in the past, and yet we know very little about it. I was painfully aware of this after Justice Guidry talked me into writing the booklet that will be out, which in the fall, I guess, which is a sort of sketch of the history of the court from its beginning to the swearing in of Chief Justice Johnson. And there are whole areas of the history of this court that await further exploration. My one hope about that booklet is that it may inspire some young, eager scholar to pick up and do more about the history of the court. It was about the history of the court and the importance of how the judges over a period of the last 200 years shaped the law, and also how the court moved from being just a three-member body into what it's become, and how, you know, some of them were rapscallions, some of them were dolts, and some of them were just journeymen, and there are some of the sharpest legal minds in the United States. And that the other thing I think it's important to save, to document the history of the court. And, you know, the fact that I had worked with the court over the years to preserve the records, the written record of the court, that's the other thing that I emphasized.
Thank you, Professor Billings, and we thank you for not characterizing any of the justices as you have identified those categories. And thanks again to these legal scholars who have enriched so much today's commemoration of the bicentennial of the Louisiana Supreme Court. And now we have a special presentation that will be both educational and enjoyable. The students of the International High School in New Orleans will present a short skit entitled An Uncommon Birth, Shaping Louisiana's Legal Tradition for Statehood, thanks to attorneys Mary Dumestry and Barry Ashe and Jeff Derouin for working with the students on this delightful skit. So please welcome the students from the International School in New Orleans.
Me entristezó de ver lo que Luisiana se ha convertido en tan poco tiempo después que mi gobierno tontamente regresó a Napoleón.
I am disheartened to see what Louisiana has become in such a short time after my government foolishly returned her to Napoleon.
Y me temo de lo que se convertiría ahora después que el pretérito francés lo vendió a los americanos advencidos.
And I fear what she will now become, now that the French pretender has sold her to the upstart Americans.
Y todo esto después que España ha tomado el tiempo para establecer la ley y jurisprudencia de España.
And all this after, the Spanish umpire has taken pains to establish civil law and jurisprudence in Spain.
La ley Castilla,
the law of Castile,
como la fuente autoritativa de la ley de Luisiana,
as an authoritative source of law for Louisiana.
The influence and role of Spain's civil law has never been questioned by me, nor the judges of the Superior Court of the Orleans Territory.
Impérialiste américain, voilà le problème. Vous oubliez que les habitants de Louisiane sont français.
American imperialists, that's just the problem. You forget that the people of Louisiana are French.
Par faiblesse et lâcheté, vous vous pliez aux lois espagnoles alors que la Louisiane a été fondée sur le code civil français.
Your weakness and cowardice make you buckle to the Spanish laws as you choose to ignore the fact that Louisiana was founded upon the French civilian legal tradition.
Et vous, gouverneur Claiborne, croyez-vous que nous ignorons votre intention de remplacer toutes les lois françaises par les lois américaines?
And all the while, don't believe we Creoles know what you're really up to, Governor Claiborne. Seeking to displace all civilian law with the English common law that prevails everywhere else in America.
Cela pourrait nuire à notre système d'héritage,
This could affect our inheritance laws,
à notre droit de la famille,
our family law,
bref, à notre droit tout entier.
our method of making legal decisions.
Oubliez-vous la manifestation de 1804 contre la domination américaine et contre la migration en tout dans Louisiane.
And don't forget the organized protests against American rule in 1804, objecting to the Americanization of Louisiana law.
Ne touchez pas à notre loi, et alors on accepteront de devenir un État d'Amérique.
Just leave our law alone and we'll be able to make the transition to American statehood.
Et, Marquis, ignorez-vous que la Louisiane a des mœurs françaises, a des lois françaises?
And Marquis, you seem to ignore the fact that Lower Louisiana is overwhelmingly French in language, manners, and yes, even legal expectations.
Et se demeurer ainsi durant toute la domination d'Espagnol?
And it remained that way throughout the period of Spanish rule.
That's what this transplanted New Yorker discovered upon their arrival to Louisiana after the Great Purchase. Even after 35 years of Spanish rule, Louisiana still remains French in its tastes, customs, habits, religion, and their language.
I played President Thomas Jefferson, and as we all know, he was one of the most influential people in the Louisiana Purchase and getting it certified as a state.
What did you learn about the Louisiana Supreme Court and the law by going through the play?
It actually made my decision for my major even harder because I'm currently battling between business and studying law.
My character was Governor William C.C. Claiborne, and the significance of Governor Claiborne was that he was the first territorial governor of Louisiana, and it was his job to broker a common ground between the French and the Spanish and the Americans so that Louisiana could become a state.
What did you learn about the Louisiana Supreme Court and the law?
I learned that it's been influenced by a lot of different means, from the French and the Spanish and Americans to English, and that it took a lot to get it based here, a lot of arguing.
What are your plans for college and a career?
My plans for college, I plan to either major in English or a form of history and become a lawyer and become a judge.
In the play, I play Senor Poydras, and he is a farmer who is fighting for French law.
Why is this important?
As you know, Louisiana is founded off principles from Napoleon Code, the Spanish law, and American law, so he played a big part in helping to manifest the whole law that we have now in Louisiana.
I played Casa Calvo in the play, and the significance of this character is that he wanted the Spanish law to be inside of the Louisiana law because of all the struggles Spain has gone through to establish that.
What did you learn about the Louisiana Supreme Court and the law by going through this?
Well, there's lots of roots in history into this law.
What are your plans for college and a career?
I want to study forensic law.
I was the translator for Poydras, and he's the Creole, the French speaker, and Louisiana started out with French, the French pursers.
What did you learn about the Louisiana Supreme Court and the law by going through this?
I learned that it goes way back. There's a lot more to it than just some lawyers and some judges. It has a history. It has a story.
I played Edward Livingston. And the significance of my character was he was the legal advisor to the president and the governor throughout this whole purchase.
What did you learn about the law and the Louisiana Supreme Court?
I learned that Poydras was very upset about everything that they decided to do. I learned Claiborne, when he thought of something, he went forward and he did it all the way, and so did Thomas Jefferson.
In this play, I was Translator 1, which is the Spanish translator for Casa Calvo. The significance of my role is basically translating everything that Casa Calvo says in Spanish so that, our audience will be able to understand what he's saying.
Why is it important that people learn about the history of the Louisiana Supreme Court?
It's important that people learn about the history of Louisiana because we're a very unique state. We have different laws and the way we set up, so it's important to know about how we became an actual state.
I played the narrator. The significance of my role was really to let the audience know who each person was and to really introduce and to basically wrap up everything that happened.
Okay. Tell me, what did you learn about the law and the Louisiana Supreme Court?
Well, one thing I learned was that I learned a lot of new characters like Casa Calvo. I didn't know about him at all. And I also learned that Claiborne was really the backbone into making Louisiana ready. And one thing about the Supreme Court that I didn't know was about just how the whole, everything worked as a whole to make what happens happen.
Would you please join me in singing the national anthem? Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Many things might appear different. You know, in 1813, obviously, we didn't have electronic filing. We didn't have video streaming to conduct our conferences remotely. People weren't able to watch the arguments that occurred in the court unless they were physically present in New Orleans, and now that can be done remotely. But fundamentally, many things have not changed. Although in 1813, the justices would have probably had to have ridden by horseback or by boat to attend sessions of court, they still perform the same basic function that we perform today, which is deciding cases revolving disputes between citizens of the state of Louisiana, and also the very important decisions involved in the criminal cases. Throughout last year, we celebrated the bicentennial of Louisiana's statehood in 2012, and one of the first things that Louisiana did as it became a state was begin plans to have a Supreme Court. And this week is the anniversary of the first sitting of the Louisiana Supreme Court here in New Orleans, so it's being commemorated, the 200th anniversary of the beginning of the Supreme Court and the judicial system of Louisiana.
The legacy of the Supreme Court is a legacy of history and tradition. The Louisiana Supreme Court's history is and reflects the history of Louisiana. Its culture, the diversity of opinion, the diversity of what makes Louisiana so very special were manifested in the many opinions of the Supreme Court over the years. Its buildings where it was housed and the people who were in those buildings who created our very strong tradition of law. Today we learned a lot about civil law and its history and the significance of civil law in Louisiana. And as that civil law developed with the traditions of law in the United States, and those traditions, how we all came to be part of this country. And I think the Louisiana Supreme Court manifests that as well in terms of its history.
The first court session, as I mentioned, was in a building called Government House, which was just north of Jackson Square, no longer exists. It burned down in the 1820s. The court then met in the Presbytere, just to the right of St. Louis Cathedral as you face in the cathedral, and then met in the Cabildo on the left. In 1910, the court moved into this building here on Royal Street in the French Quarter, which was built not only for the Supreme Court, but for all the courts that were in existence at that time, and also the administration of the city's governance. The court then moved to a location near the Supreme Court on Loyola Avenue in the 1950s and returned back to this building in 2004 after a very extensive renovation of this particular building. I just think it's very important for Louisiana to always take note of its rich history. We've got more history within a doubloon's throw of where we stand right now in the French Quarter than virtually any other city in America, probably outside the 13 colonies. And the judiciary, as well as the legislative and executive branches, have been at work for the entire existence of Louisiana statehood. And to prepare for the future, you always have to learn from the past. And I think it's wonderful that the court is commemorating this anniversary the way they're doing.
I thought it was spectacular, and I love the way they emulated the ceremony that took place here exactly 100 years ago.
Oh, it's been very exciting. It's good to get together with folks who are interested in Louisiana legal history, especially the civilian part of that tradition.
I'm impressed. Who would have thought that I would have been involved in it, considering, say, 50 years ago, my parents had just begun to vote in the 1940s, and here I am as one of the spokesmen for it.
This has been fun because I've been involved with it in one way or another for, what, 2 years or more. So I think this has been a good thing. It's always a good thing when people, ordinary folks, get to see courts up close and personal, and I think that sort of thing was to the good.
We are really all small links in a very long chain. One of the things that we did to celebrate the court's bicentennial was have an actual court session in the Cabildo, in the same room where the Supreme Court met for many years. And you know, the windows were open there, you could hear the noise in the street, and it was very easy to imagine that we were back in that period of time in New Orleans history, in our state's history. It was very sombering and humbling to realize that at that time, 200 years ago, these justices were meeting in the same fashion that we're meeting today, deciding cases the same way that we're doing today. And we're just one more link in that long chain, really unbroken chain, that is established the rule of law in our state.
In the same way that all history should be preserved, because from our history we learn about how we got to where we got today. So much of what we learned about today, I think, makes clearer where we are as a people in terms of the importance of freedom and fighting hard for freedom, the rule of law and its significance. In Louisiana, this is very important to us as well.
It's been a great day. You've got some of the brightest jurists around that have been at it for a long time, serving the judiciary in various positions. And you have former Chief Justices and former Justices of the court here, many of the appellate court judges, district court judges, and of course the sitting Supreme Court. So it's a great day for legal scholarship in Louisiana.
I hope that future justices take their role as seriously as those that have come before us did theirs. That they realize that the importance of the court, that they realize that we can't confuse the person with the position, and that when we're gone, there'll be another group of justices that will take our place, and hopefully that they will do a good job, take it very seriously, and just carry that tradition forward into the future.